Thank you, Madam Speaker. Just a few questions, if I may, to the proponent of the bill.
Representative Blumenthal, please prepare yourself. Representative Smith, please proceed.
Thank you. So listening to Representative Dubisky, the question in my mind popped up, if this is nothing more than a hunk of metal or a piece of plastic that we're voting on tonight, I'm wondering, when does it really, under this bill, when does that hunk of metal and that piece of plastic or that material become a ghost gun or a gun under this bill? Through you, Madam Speaker.
Representative Blumenthal.
Thank you, Madam Speaker. Through you. So it becomes a ghost gun in one of two ways under this bill. One is through Section 2, upon the completion of a firearm, which is a functional firearm under Section 2. And the other is an unfinished frame or lower receiver, which we've defined as a blank casting or machine body intended to be turned into a frame or lower receiver of a firearm that requires additional machining, but most major machining operations have been completed, even though the fire control cavity of that blank casting or machine body is still completely solid or unmachined. So essentially, once major machining operations have ended, even though that fire control cavity is still blank and unmachined, and an intent for that casting or blanked is developed into be turning into a frame or lower receiver of a firearm, that is when Section 5 would go into effect. Through you, Madam Speaker.
Representative Smith.
I thank the representative for the answer, and just to dig down a little bit deeper then, so if I buy and forgive me if I misspeak here because I'm not a gun owner, but if I buy a lower receiver that's already been machined, but still needs more work, but I have no intent to do anything further with it. I just bought it. I like how it looks. I'm going to keep it in my room, or I'll display it in my living room. But I have no intent to make a gun out of it. Based on what I heard this evening, under that scenario, and correct me if I'm wrong, that would not be a violation of this bill. Through you, Madam Speaker.
Representative Blumenthal.
Thank you, Madam Speaker. Through you. That is correct. If you have such an item that would require more machining, become a frame or lower receiver of a firearm, but you do not have the intent to convert it into such a frame or lower receiver, it is not yet an unfinished frame or lower receiver under Section 5.
Representative Smith.
Thank you, Madam Speaker. So how is one to prove that intent? So if someone buys it, but it's machined already, and it could certainly be, if machined further, converted into a weapon or a firearm, how does one go about proving that I or you or somebody else had the intent to actually convert it to the firearm? Through you, Madam Speaker.
Representative Blumenthal.
Thank you, Madam Speaker. Through you, a prosecutor would prove it the exact same way a prosecutor proves intent under any other offense listed in our criminal code.
Representative Smith.
Well, I would think, thank you, Madam Speaker, I would think it'd be a tall order, because without any type of other evidence of prior intent or knowledge or capability or whatever, I think it's a tall order for police to actually make an arrest because somebody purchased a product that had the capability of becoming a gun. So that's where I'm a little concerned, and I don't know if these statistics that Representative Dubisky mentioned are accurate in terms of the prosecutions of those persons arrested with possession of a weapon. But under this particular bill, I don't know how the police would actually prosecute someone for just purchasing this product over the internet, or I don't even know if you can go into a store and actually buy these. Maybe you can. That's how little knowledge I have of this area. But it seems to me we're setting up a bill for failure Now, I commend the committee, and I commend the gentleman who put the bill together, and I know it's been worked on by a number of folks to make this bill a lot better than certainly it was last year, and it is better. But I still think it has a ways to go in the sense of just being able to prove intent. And I'm also looking, Madam Speaker, at Section 2, subsection B, and it talks about a 30-day period or a 90-day period after the department actually publishes its regulations, I guess, that it's ready to receive the information it needs to give a serial code to the weapon. I'm thinking logically, how does one actually know when that clock starts ticking? The person who really knows when the clock starts ticking is the one who actually developed the gun or manufactured the gun. So how does one start the clock? If the gentleman understands my question, through you, Madam Speaker.
Representative Blumenthal.
Thank you, Madam Speaker. Through you, the clock would start at the point at which the person completes the manufacture or the firearm, and it would last for 30 days. However, if the department, it has not yet been 90 days after the Department of Emergency Services and Public Protection has provided notice in accordance with Section 3 of the Act, which is the process for actually obtaining a serial number, then whichever is the later of those two dates, 30 days after the person completes the manufacture or 90 days after the department has provided notice, those would be the time limits for the person to contact the department and seek to provide them the requested and required information and seek to provide the mentioned serial number. Through you, Madam Speaker.
Representative Smith.
Again, thank the gentleman for his answer. And it's, again, just a concern I have about the ability for anybody to actually start that clock ticking. Just two more questions, if I may, through you, Madam. I know we just got the strike all language tonight, so just skimming through it, but is there any language in here that provides for any funding for any mental health issues? I know when we did the Sandy Hook, the comprehensive Sandy Hook gun bill, one of the integral components of that particular bill was to make sure that we fund the issues that we have in this state dealing with mental health and those having access to weapons. And I think, honestly, we've done a poor job in that respect. We passed the law and did some grandstanding at the time about passing that law, but the mental health aspect was kind of let go, in my opinion. And I'm wondering if there's anything in here that deals with that. Through you, Madam Speaker.
Representative Blumenthal.
Thank you, Madam Speaker. Through you, this bill contains no funding of any kind and does not deal with mental health. Through you, Madam Speaker.
Representative Smith.
And I thank the gentleman for his answer, and once again would encourage this chamber going forward that anytime we bring gun bills before the chamber and before the legislature, that we consider that aspect, because it's been shown over and over again that the issues that we have, or many of the issues that we have with gun possession and gun violence, goes back to mental health issues. So let's not ignore one of the major components and one of the major issues that we have here in Connecticut. And lastly, through you, Madam Speaker, I noticed in subsection G, it talks about a suspension of prosecution. Are we talking about the eligibility of applying for the AR program, through you, Madam Speaker?
Representative Blumenthal.
That is, through you, Madam Speaker, that is subsection G of which section?
Representative Smith.
Well, I have to put my glasses on, Madam Speaker. I still think it's under, well, it's throughout the bill, but under Section 2, subsection G, it talks about suspension of prosecution. It seems to me that would be an AR application, but it doesn't really specify AR. Just wanted to see if it is. Through you, Madam.
Representative Blumenthal.
Thank you, Madam Speaker. Through you, it is not officially an AR program. It has specific requirements, including that the judge find that the violation of the relevant section is not a serious nature, and that the person charged with the violation will probably not offend in the future, has not previously been convicted of a violation of this particular section, and has not previously had a prosecution under this section suspended pursuant to this subsection. So it is a specified suspension of prosecution provision, particular to each section of this bill that it's relevant to, although it echoes other parts of our firearms law, especially with regard to the transfer of pistols and revolvers. Through you, Madam Speaker.
Representative Smith.
Thank you, Madam Speaker. So just to one more question as a follow-up then, just to get into the actual real world. So if somebody's been arrested, if this bill becomes law and somebody's arrested and they're appearing before the judge, they would then have to file a motion for suspension of prosecution under this particular section to ultimately, if compliant, have the charges dismissed. Is that correct, through you, Madam Speaker?
Representative Blumenthal.
Thank you, Madam Speaker. They could either make such a motion or they could plead to the offense. There are a variety of ways to exercise it. The key element is the element of discretion with regard to the judge, the underlying requirements. And the idea that this provision is meant to address the situation where somebody makes an accidental or violation that's not of a serious nature, and they don't have an intent to do it, or they aren't likely to attempt to do it in the future, and that they understand the meaning of what they're doing under the suspension provision. Through you, Madam Speaker.
Representative Smith.
I keep saying lastly, but I hope this is the last question, Madam Speaker. Would somebody be eligible under our current AR legislation or statutes? Would they be eligible to apply for AR if this bill were to become law? Through you.
Representative Blumenthal.
Thank you, Madam Speaker. Through you, I see no reason why they would not be able to.
Representative Smith.
I thank the chamber for its time. Thank you, Madam Speaker.